All right, to promote the concept of having a fresh start post-bankruptcy filing, the state of Nevada does provide what are called exemptions. Again, this is one of those key concepts we talked about early on in the class. I want you to make sure that you understand what that means. Be mindful, though, that you do have to have lived in the state of Nevada for at least 2 years for you to be able to benefit from these exemptions. If you are married and you're filing jointly, you are able to do what's called stacking or double the exemptions, and I'll give you an example of that in just a few minutes. But bottom line, we've given you a list here on page 8 of all the different exemptions that are allowed. Number 1, cars. If you own a car, then you can claim $15,000 against that car as far as exempting the vehicle, which means that your car is protected from the trustee for up to $15,000 of equity. Number 2, clothing. You're allowed to keep reasonable amounts of clothing. Of course, we ask that you're not keeping mink coats or Gucci purses or anything that would have value that a trustee might be able to take and sell to create a pool of money to pay off creditors. Household furnishings up to $12,000. This includes appliances, furniture, linens, those kinds of things. Again, remember, the general premise behind this is that they're trying to give you a fresh start. They don't want to leave you destitute with nothing in your home. That wouldn't be much of a fresh start now, would it? So that's something to keep in mind. Art, jewelry, instruments, keepsakes, up to $5,000. Pensions and IRAs and 401k, those also enjoy an exemption of up to $500,000 in the state of Nevada. However, you have to keep those funds intact in those types of accounts for them to remain exempted. Primary residence, this is the homestead exemption I mentioned earlier. Nevada is very generous. It has a $550,000 exemption. They do have a couple of requirements. One is that you have to have owned the home for 1,215 days previous to filing bankruptcy, and that time is accounted from the date of filing. Tools of trade, up to $10,000. This is important because let's say hypothetically you're a plumber and you own a vehicle and you've already used your auto exemption that we referenced earlier, but you have a third vehicle that may be able to be saved underneath the $10,000 tools of trade. It is for instance, your plumbing vehicle, and all of your tools are in the plumber's vehicle. So that's a good one to keep in mind. Public benefits such as workers' comp, unemployment, food stamps, those kinds of things, those are all going to be exempted, and the trustee's not going to be concerned about taking those as an asset. 75% of your paid wages, unspent Social Security income. Well, I want to just clarify what that means. If you have a Social Security as your primary and only income, let's say, but you purchase something with it, like a television set, well, your Social Security income is going to be exempt, but the television set is not going to be exempt. It's lost its status of exemption based on you using your Social Security money to spend it. Personal injury settlements up to $16,150. Now, pain and suffering and lost wages, those are not capped. You're able to claim those as exempt for whatever amount that you might have received. Restitution received by a crime victim, and a wild card exemption. This is my favorite. This means that you can use it for absolutely anything that you own, $1,000. Let's say, for instance, that you have $450 in a checking account and it's not exempted under anything else. You can use the wild card for that. Now, I want to give a couple of examples of equity and exemption and how that applies. For example, if you have a home that is worth $650,000 and you have one loan on it that's $300,000 and you have a second loan on it that's $100,000, the equity remaining in that property is $250,000. Well, that amount is exempt, and a trustee could not seize your home, sell it, and take that $250,000. That amount is exempt because it's under the $550,000 amount. Another example would be a vehicle. If you have a fair market value on your vehicle of $6,500, you have a loan that's $3,000 on it, that means that you have equity of $3,500. Again, it's less than the $15,000 allotted amount, so that vehicle is going to be exempt and you don't have to worry about a trustee taking it. Now, just to do a quick example of stacking and doubling, let's say you're married and you're getting ready to file bankruptcy and you have two vehicles. Well, each of you gets to claim $15,000 on each vehicle, or in the alternative, you can double it. So let's say hypothetically you have a vehicle that has $30,000 in equity. well, you would double your vehicle exemption, and you would be able to protect it from any seizure from the trustee. Does everybody understand? Good. Okay, next page. We're going to talk about property that is not exempt, that the state of Nevada has not provided protection for. That includes non-residential real estate, commercial property, vacation homes, or rental homes. Recreational vehicles such as RVs, mobile homes, travel trailers, ATVs, additional vehicles outside of the one or two, depending on whether you're filing jointly or individually. Those vehicles would not be protected. Valuable collections, such as a stamp collection or a fine china collection, something of value significantly. Family heirlooms, unless they're under the $5,000 exemption amount that I had mentioned earlier, the family heirlooms, keepsakes, those kinds of things, you might be able to exempt the family heirloom under that amount. Savings, excess cash, bonds, or investments not covered under a pension exemption, and again, those funds that would not be covered by the $1,000 wild card. Those are the items that are not going to be exempt. Now, if you were interested in keeping a piece of property that does not enjoy exemption protection, there are three things that you will do, two things in particular, but three things that will happen with every asset that you own when you file bankruptcy. You can, 1, redeem, 2, reaffirm, or 3, surrender. And I'm going to explain. Obviously, I think most of us understand the concept of surrendering. That means you would just be giving it back to a secured creditor, or you'd be surrendering it to the trustee. But let's talk about redemption real quick. What that means is you might negotiate with the trustee that you would like to buy back the asset. And so you would be able to discuss that with the trustee, and you would pay X amount of money for that asset. That would be strictly up to the trustee, but you could have that discussion. Number 2 is a reaffirmation. This typically happens with a secured debt, such as a car. If you'd like to keep your car, and we're going to talk about it a little bit more later, but it's called a reaffirmation agreement, and you are going to reaffirm the debt. Now, you will identify these either redeem, reaffirm, or surrender in what's called a statement of intention, which is one of the documents that you will actually file when you file your bankruptcy, and we'll talk about that a little bit more in detail when we discuss the forms section. Okay, next up we're going to talk about filing documents and the automatic stay, but right now let's take a break. Moving on. Okay, now we're going to talk about filing documents and the automatic stay. Again, remember, this automatic stay was one of the key points I had mentioned earlier, so I want to make sure that you understand it, so don't hesitate to ask questions if it's not clear. We're on page 9 and moving on to page 10. All right, when you're getting ready to file your documents, it's quite voluminous. There are many documents that we need to gather to actually initiate the bankruptcy relief. The first one is called a petition. It's a voluntary petition that you file, which actually gets the bankruptcy started. With that are documents that we call schedules. They're A all the way through letter J. This is going to include everything from all of your property listed to all of your debts listed. It also include your income and your expenses. And we're going to talk about that in a little bit more detail later in our forms section, but just be mindful of that. There's also statement of intention with a Chapter 7. That refers to the document I suggested earlier when you're going to redeem or reaffirm or surrender your an asset, And then finally, Chapter 13 is a repayment plan. That is something that we'll also talk about briefly later in the forms section. You're also going to file a creditor matrix. This is the document that you list all of your creditors' addresses so that we ensure that they're getting the notice of your bankruptcy properly and efficiently. And also a statement of financial affairs. This is a list of questions, as many as 25. I don't remember exactly the number, but it's very detail-oriented, and we will talk about a little bit more detail later, but it does really dig into your financial affairs and is one of the documents, the main documents that the trustee considers when he's preparing for his 341 meeting. To file Chapter 7, it is $290.